Jacob Zuma Foundation says it is astounded by the vagueness and ambiguity in the decision by the Supreme Court of Appeal to dismiss his bid for leave to appeal. The court on Thursday dismissed the former president's efforts to have prosecutor Adv Billy Downer removed. The foundation says that Jacob Zuma's legal team will approach the president of the Supreme Court of Appeals to seek remedies, including reconsideration and clarity of the decision. Is there any prospect of success? Vanessa de Silva, Faria, director of the Ulrich, Roux and associate, joins us to talk more on this particular matter. Vanessa, good to have you with us tonight on In Focus. What step in the process is this process of re-engaging the president of the Supreme Court on a decision that has already been made, and what provisions are there for such an action to be taken?
Hi, and thank you for having me. It's quite an interesting step. There are provisions in the Superior Courts Act that makes provision for this particular approach to the Judge President of the Supreme Court of Appeal. And in essence, what Jacob Zuma's team is trying to do is to ask that the Judge President reconsider his own judge's decision on this appeal. Now, the section is very far and wide, and it specifically requires that exceptional circumstances are illustrated as to why this appeal needs to be reconsidered, and why the decision of dismissing the appeal is incorrect, and what prospects of success there are in having it reconsidered.
So now, what they're saying in their statement is that court judgments are there to provide legal certainty and clarity so that subjective inferences are avoided. If you look at that judgment from the Supreme Court of Appeals, are there ambiguities there? Are there things that need to be clarified out of that judgment?
Well, I haven't seen the written judgment of it, but I assume when you're referring to the order, you're referring to the order in itself, where it says that the appeal is dismissed and that there weren't any compelling reasons as to why the appeal should proceed. And on that note, I think that there is some certainty or clarity that we require, because that particular paragraph where they say that there aren't really compelling reasons as to why an appeal should proceed implies that the entire dispute in itself perhaps may not be appealable, in the sense that in our law, only final orders and final decisions are subject to appeal or are appealable. Interim decisions and interlocutory applications, which is essentially what one would argue a special plea is not appealable. So I think on that premise in itself, perhaps that's something that the deputy or the Judge President is able to give us clarity on. But I think that would be the only thing within that order that requires clarity. Yeah.
So in simple terms, what they're saying is we want the exact reasons why our appeal was dismissed, and we are not quite sure at this particular point as to why. How does that process work? Is this an issue of just writing to the Judge President, the Judge President then responding to saying these are the reasons why? And how does that work out as far as the process is concerned? Because, of course, this is, as you mentioned, it's an interlocutory application in the whole case of the corruption trial of former President Jacob Zuma.
Yes, well, the process is submitting representations to the Judge President and to ask him to give us reasons and to also explain, whether or not he agrees with the decision. And the real effect of that is that they get to understand the legal reasons as to why the appeal was dismissed. Now, the only other solution that Jacob Zuma has is to then approach the constitutional courts. And it could be, an assumption that he's essentially waiting for those reasons to see whether there is any constitutional element that he could bring in his attempt at later on approaching the constitutional courts to then review what the Supreme Court has said.
So does this process then have the effect of delaying the arms deal trial?
Well, I would argue that it doesn't. The fact of the matter is that the Supreme Court of Appeal has made a decision that granted an order. And the NPA has made it clear that they're in a position to proceed, and they must proceed. Legally speaking, I think the request or the submission of possible representations asking for reasons as to why the appeal was dismissed doesn't suspend the fact that it was dismissed. It's still a final order that's been granted in the sense that the appeal has been dismissed. There's nothing pending in the air which could possibly delay it legally, unless Mr. Zuma decides to bring an application to the Constitutional Court before then.
Yeah. So, I mean, there is certainly a hope from their statement that there could be a reconsideration, a variation of this particular decision over and above the clarification that they seek. What would it take then to have this decision reconsidered or varied in any way?
Well, it's not as simple as just having it reconsidered or varied, and it's very doubtful that the judge president would just simply overrule two of his very high, profound judges' decision. I think the real issue is he needs to provide reasons for that, and the only solution or the only possible outcome that Jacob Zuma could then have is to find some kind of constitutional element. And that's really all that it will take for it to then present itself to the Constitutional Court. At the end of the day, if the Constitutional Court finds that his appeal has some merit in it, and that his application, in essence, has some merit in it, then that will only really be his rescue at the end of the day.
Yeah. And in this particular instance, is the defense at all involved in this process as they seek clarity from the judge president?
Well, yes, both parties would be involved. Jacob Zuma's legal representation obviously would be pushing for that response from the judge president, but the state will be likewise involved in receiving that response and understanding exactly what those reasons were. As well, if Mr. Zuma had to approach the Constitutional Court, it would be something that would have to be served on the state, and the state would have an opportunity to oppose that application as well.
And the presiding judge in the criminal matter seemingly has been copied in this particular correspondence. Is that something that is critical? Will the criminal trial judge be looking at this correspondence and bringing it into consideration at all?
I think that's more of a strategic move than anything else. By doing that, I think it's quite clear that they will be attempting to argue a postponement on the next court hearing, a postponement on the premise that the matter can't proceed until a reason has been furnished by the judge president of the Supreme Court of Appeal. And as I said earlier, I think it's arguable as to whether or not a postponement in those circumstances is warranted and should be granted. But that definitely gives us an indication of what their strategy is for the next court appearance.
Vanessa, appreciate your time. Thank you so much for coming through and bringing that clarity there. Vanessa de Silva, Faria, director at the Ulrich, Roux and Associates.